Today, we're going to continue our journey in contracts with Chapter 14, Voluntary Consent. Here's the general rule for voluntary consent. All agreements must be voluntary to be enforceable. Thus, if an agreement was not voluntarily entered into by both of the parties, the general rule is that the contract will be voidable most of the time. There is one exception when the contract will be void, but the general rule is when there's not voluntary consent, the contract is voidable, which means the person may cancel the contract. Let's look at some of the behaviors that take away voluntary consent. There are 5 behaviors that take away voluntary consent, even though the slide shows 4. Again, there are 5 behaviors that take away voluntary consent. The first one is non-fraudulent misrepresentation. The second one is fraud. Number 3, duress. Number 4, undue influence. And number 5, the one that you don't see here on the slide, is mistake. So again, number 1, non-fraudulent misrepresentation. Number 2, fraud. Number 3, duress. Number 4, undue influence. And number 5, mistake. The next several slides will talk about each of these behaviors in greater detail. The first one I want to talk about is non-fraudulent misrepresentation. I know it says misrepresentation on the slide, but I want you to know it's non-fraudulent misrepresentation. Let me give you the definition of misrepresentation. Misrepresentation occurs when one of the parties to a contract created in the mind of the other party a mistaken impression about an important fact or facts concerning the subject of the contract. In order to have non-fraudulent misrepresentation, there are 5 elements. Let me list the elements and then we'll go through each of the 5 elements of non-fraudulent misrepresentation in greater detail. The first element is false statement. Number 2, materiality. Number 3, fact. Number 4, justifiable reliance. And number 5, detriment. As noted, the first element of non-fraudulent misrepresentation is false statement. The statement merely has to be false. In essence, it does not require any proof that the person making the statement knew that the statement was untrue. Thus, the false statement can be an honest mistake. Number 2, materiality. The false statement must be material. Thus, the false statement would contribute the average reasonable person to enter into a contract, or TARP. The third element of non-fraudulent misrepresentation is fact. Thus, the false statement that is material must be a fact and not just merely opinion. So it must be a present or past fact. Thus, statements such as statements about future events or opinion or puffery do not suffice as fact, but are merely opinion. The fourth element is justifiable reliance. The injured party must have relied on the false statement of material fact. Thus, it would not be justifiable reliance if the plaintiff could have readily discovered the facts that made the statement false. The final element of non-fraudulent misrepresentation is detriment or injury. Thus, the plaintiff would have been in a better position if things were as they had been represented by the person who made the false material factual statement that was justifiably relied on. The second behavior we want to look at is fraud. Remember, the first behavior we just looked at was non-fraudulent misrepresentation. So the difference between non-fraudulent misrepresentation and this behavior, fraud, is that the first one isn't fraud, and obviously the second one here is fraud. Here's the definition of fraud. The intentional misrepresentation that was knowingly made with the intent to deceive. So thus, in order to prove fraud, you must prove the 5 elements that I laid out in non-fraudulent misrepresentation plus 2 more. Number 6, the statement was knowingly made by the defendant. And number 7, with intent to deceive, otherwise known as scienter. Let's look at elements 6 and 7 since we already talked about the first 5 with non-fraudulent misrepresentation. The 6th element that a plaintiff must prove in order to prove fraud was that the statement was knowingly made. Thus, the plaintiff must prove that the defendant knew the statement was untrue or possessed enough information so that he or she should have known the truth, or made the statement without sufficient information, known as recklessness. The 7th element is intent to deceive, otherwise known as scienter. Scienter looks to the mental statement of the person who made the statement, the defendant. So the plaintiff must prove that the defendant made this statement knowing, trying to deceive the plaintiff, or took action to conceal something. The hard part about proving scienter is you may believe that the defendant made this statement, but it's hard to prove that the defendant made the statement with intent to deceive. If you can prove only the first 5 elements, you have non-fraudulent misrepresentation. If you can prove all 7 elements, then you have fraud. Fraud allows the plaintiff to get greater amount of damages because here you proved intent by the defendant. So when you can prove fraud, you will get greater damages than if you can merely prove non-fraudulent misrepresentation. A couple other factors we want to talk about fraud. First, let's look at fraud by silence, by not saying anything or keeping your mouth shut when you should have spoke up. There's a difference between the common law and the modern law with regards to fraud by silence. Under the common law, silence was a defense for the defendant. In essence, we went by the old Latin term caveat emptor, translated, let the buyer beware, which means the defendant had no duty to say anything. The modern approach is different. Under the modern approach, silence by the defendant can amount to fraud if the plaintiff could not have discovered the fraud by a reasonable inspection and would be unlikely to inquire about it. You need both. One other thing I want to talk about fraud is fraud in the execution. Remember, at the beginning of today's lecture, I said most of the time contracts are voidable. This is the one instance in fraud in the execution where if proven, the contract's not voidable, but rather void. No contract at all. So this is a fraud where you get someone to sign something saying it's one thing when it's really something else. So if I were to example, tell one of my students, hey, sign this piece of paper, and the student quickly signs it, and then they didn't realize they were signing away the deed to their house, that would be fraud in the execution or signature. This type of fraud is void. The third and fourth behaviors can be discussed next. The third behavior that invalidates voluntary consent is duress. Duress is when one of the parties, by making a threat of harm, force the other party to enter into an agreement that he or she would not otherwise have entered. In order to prove duress, the plaintiff must prove that the threat was actually wrongful. Therefore, threats such as driving a hard bargain to get a better financial deal or threats against people in a well-founded civil suit is not wrongful, and if it's not wrongful, it doesn't rise to the level of duress. If you can prove duress, then the contract is voidable. The fourth behavior that invalidates voluntary consent is undue influence. Undue influence seems a lot like duress, but it's different. Under undue influence occurs when there is exerting influence by a person over another person based who's in a dominant position and based on a confidential relationship. So again, number one, in a dominant position based on a confidential relationship. It's very fact specific. So maybe like, for instance, a priest is in a dominant position based on a confidential relationship over his or her congregation, or an attorney is in a dominant position based on a confidential relationship over his or her client. I'm going to skip over slides 7 and 8 and come back to them, and then move over to slide 9 to talk about the fifth type of behavior that invalidates voluntary consent. Mistakes. And a mistake is when one or both of the parties to an agreement acted under an untrue belief about the existence or non-existence of a material fact. If you have a mistake, generally it prevents a meeting of the minds that is necessary for an agreement. Remember, offer plus acceptance is a meeting of the minds. Let's look at what type of mistake it is, because the type of mistake will have ramifications. The mistake could either be a mutual mistake or a unilateral mistake. If it's a mutual mistake, it's always the basis for granting rescission of the contract. Because if both parties had a mistaken belief about a material fact, either the existence or non-existence of a material fact, then it's not fair to go through the contract. However, it's different for a unilateral mistake. In a unilateral mistake, only one of the parties is acting under a mistaken belief. The general rule about a unilateral mistake is that rescission or getting out of the contract is usually not granted. There is an exception that courts will grant a unilateral mistake and allow the person who was mistaken to get out of the contract if the person was truly mistaken and a serious injustice would result from enforcing the agreement. Moving back to slides 7 and 8. What is the remedy when we have any sort of behavior that invalidates voluntary consent? Well, it's going to depend on where we are within the contract. If the contract has already begun and a party is actually injured, the injured party may rescind or cancel the contract and either return what he or she received under the contract and or recover what he or she gave under the contract. If no performance has been rendered yet, the injured party may just disaffirm or cancel. So Again, here, if the injured party can rescind the contract if it's already started or cancel and go back to the position he or she was in, if no performance has been rendered, really the party who would have been injured may just disaffirm. Finally, one must be careful about ratification here, because if you entered into a contract without voluntary consent, you must act promptly to rescind or disaffirm the contract. If you wait too long to either rescind or disaffirm the contract, in essence, you ratify or agree to the contract and lose the power to rescind the contract. This concludes today's lecture on Chapter 14, Voluntary Consent.